Welcome to the Confident Retirement Podcast. Is doing the most important things alone a good idea? How comfy are you with your choices when it comes to life's biggest decisions? What is real peace of mind with financial confidence, and how can you get it? Chris Fleming and Mark Peachy are the founders of LPF Advisors in Sarasota, Florida. On the show, they bring together the best and brightest minds to share with you how to have a more confident financial picture. They empower listeners with simple, common sense and financial wisdom. And now, here are your hosts from LPF Advisors.
Hey, I want to welcome everybody to the Confident Retirement Podcast brought to you by LPF Advisors. I am your host here, Chris Fleming, as always. And today I have the honor of hosting Taso Milonas, a Florida bar certified lawyer with a master's degree in taxation. His practice involves will and trust contests, we'll get into that a little bit, representing for fiduciaries, beneficiaries, and a variety of tax matters. Taso has been recognized as a Florida super lawyer, I don't see his cape, and a Florida's Trend super elite, whatever that sounds pretty amazing. Taso, thanks for being here and welcome to the show.
Thank you, Chris. Good morning.
Yeah, we're going to have some fun. So I'm sure you have an interesting history. We were talking a little bit before we went on air. So take me through your story of what kind of led you to where you are today.
50,000 foot view. I started off wanting to become an admiralty lawyer. I'm Greek background, born and raised in Tampa, 7th largest port in the country. Fast forward, I became a wills and trust lawyer. And I'll spare you the boring details in between, but I've enjoyed it. I like to say I'm a recovering tax lawyer. I am board certified in tax law. I've spent most of my practice doing transactional law. These days, the lion's share of my practice is trust and estate litigation.
Okay, awesome. And we're going to get into that. I'm really interested in learning more about that. So is there something that you know now that you wish you knew when you started out? If you could go back and talk to the younger you, what advice might you give that person?
The younger me, I think, would be more of a generalist.
Okay.
My wife is my muse. I've been practicing almost 40 years. And I have started off in a very specialized area. You know, I'm not just a lawyer, I'm a tax lawyer. And within tax, it was traditionally estate and gift taxation. So very, very, very narrow head of the pin. But I think to be a good practitioner, and I've had the opportunity to mentor a lot of young lawyers as well as law students, both through the Florida bar programs that sanction the mentorships as well as independently. And I just try to tell them to get as much experience, be that sponge. And so I'll talk to a young tax lawyer and say, you should sit in on a real estate close. Well, I'm not a real estate lawyer. You should sit in on a trial. Oh, I'm not a litigator. I was like, I spend a fair amount of my time in the United States tax court. And so whether I'm doing a deposition in civil litigation or a deposition for the United States tax court, a deposition is a deposition, preparing discovery, preparing pleadings. And so I just try to encourage. Now I'm an old guy, but for the younger folks, if I was now the mentor telling the mentee, just have a bigger, broader picture, try to get as much experience in as many areas as you can, because those skill sets will usually come back and help you. You might not be able to, either the dots are there, and at the time you may not be able to connect them and they may not be connectable, but at some point it all kind of makes sense. And so I think it's helpful for lawyers and folks generally, just to try to have as much experience and be as well-rounded as possible.
Awesome. I like how you said that. And I was thinking as you were talking that even in like athletics and stuff like that, typically your NFL players, your NBA players, your high-level athletes, usually they were multi-sport athletes. They were in various sports. They didn't just specialize in one particular one. And the statistics show that when they kind of spread themselves out and had diversity in this type of sport they were playing, those are the ones that made it further along as it's measured by who made it to the top ranks. So,
you'll see. I actually had one, a 300-pound NFL linebacker who takes ballet class.
Yeah,
gymnastics. No, it's muscle memory. It's like this guy's a monster. He's in there with 11-year-old. It all relates.
Yeah. Hopefully you don't have any video on that.
No, I don't. It's not a pretty picture.
Yeah, exactly. All right. So are there some areas of expertise in your practice that you find to be the most challenging right now?
The challenge with what I do is you kind of have to be at least know enough to be dangerous about a lot of different things.
Okay.
And so, as an estate planner, we're drafting documents to pass a family and individual's property, business interest onto the surviving spouse, children, next generation, charity, whatever. That said, that has to translate into what those assets are. So whether it's a car dealership, whether it's a cattle ranch, whether it's an IRA, whether it's life insurance proceeds, real estate, commercial, residential, you have to know a little bit about each one of those, of how those transfers get affected. So I'm not a securities lawyer. I have a lot of go-to real estate guys, both for commercial, residential. I've taken a lot of companies, sold a lot of companies to public companies and private companies, but I'm not a securities lawyer. But you have to know enough at least to maybe get it to the next level. So in that sense, I'm quote unquote expert in my area as far as, I like to say when we do the documents, it's kind of like when you're going to a contractor and you're building a house. We're at the blueprinting stage and then we get the house built. But you need a certificate of occupancy. You need to get the electricity, the water connected. You need to have the furniture moved in. So I'm kind of that generalist at that point of getting the overall plan constructed, and then to the extent I can help facilitate the actual moving in process or lateral it to folks that do specialize. So you kind of become like a general contractor of someone's estate plan, if you will.
Yeah. And another sports analogy, it's almost like quarterbacking. I feel like that's a role I play a lot for clients, knowing enough to get them to the right people or into the right spot, and then let them handle their expertise in either taxation or estate planning while I'm still quarterbacking the client's situation and coordinating all of that. Okay.
It's like the physician, you don't go directly to the brain surgeon, don't go directly to the heart surgeon. It's usually going to be your internist, your primary care physician, and they're going to say, oh, you need this, and they're going to get you to where you need to do. So to the extent it's something we can take care of, and to the extent we need to refer on, it's definitely a team effort, collaborative work with a lot of financial planners such as yourself, insurance people, real estate people,
whole team.
Yeah.
All right. So let's dive into some basics on estate planning. And I like to dispel misconceptions or talk about things that maybe people have the wrong idea about. So I often hear people say, or clients say, this probate's no big deal. It's not really, whoop-de-doo, and it's not going to be that bad. It's not going to take that long. It's not really going to cost anything. So why is that a big misconception that people have?
If I can kind of rephrase that a little bit, it's in and of itself, the probate process is not particularly difficult, not particularly onerous. Mm-hmm. If I'm probating $100,000 estate or $100 million estate, the steps that need to be taken, the forms that need to be filed through the state court, through the local circuit court, generally going to be the same. The numbers change, but pretty much there's a checklist. Pretty much we get all that stuff filed. Yeah. The pushback from a lot of clients is the fact that it is a public proceeding. A little less so than it used to be, but everything you do has to be court supervised. So we need to file the will. We need to file the death certificate. We need to file papers getting the individual who's been named personal representative in the will, assuming there's a will, to have authority. So someone says, my mom died, my grandfather died. I'm going to just go down to the bank. I'm named personal representative in his will. Well, you're named personal representative, but unless and until the court actually appoints you personal representative, you're not. Go down to that bank with your grandfather's will, and they're going to show you the door. And they're going to say, come back after you've been to the probate court. Under Florida law, every personal representative must be represented by Florida counsel. Now, that's probably a lawyer relief act, but it is what it is. So, in general civil litigation, someone's in small claims court, they can represent themselves on their own, what they call pro se. Not so in this area. So a fiduciary, a personal representative of an estate must be represented by Florida counsel. So, that's going to cost a few dollars. So you've got a proceeding that under the current rules, generally from the time the personal representative is appointed until the conclusion of that estate. So the commencement to conclusion, alpha to omega, is generally a year-long process. And so people are, when do I get my money? When do the bills get paid? That becomes a wear on people, both financially, emotionally, and a lot of other things. They've sustained the loss of a loved one typically, and now they're having to deal with a year's worth of filings. Part of the issue, though, that the bigger problem is when people say probate only affects assets that are in an individual's individual name.
Right.
So what does that mean? So typically most clients are going to have some joint property. Maybe they have their home, husband and wife have their home jointly owned. They're going to have a brokerage account with you. They're going to have a bank account, maybe some life insurance policies, IRAs, whatever. All those assets, and all those assets may be titled differently. They might have an insurance policy naming a former spouse. They've got all these things out there. And then they go to the lawyer and they get a will. And the will says, I leave everything to my wife, who I really, really love and I really, really mean it. They've got all this other stuff out there. And they've got $100 in a bank account. They've got $1 million of life insurance. They've got $1 million with you. They've got $1 million. And they have $100 in a bank account. In that scenario, the only asset that passes by probate is the $100 bank account. All those other things are going to pass. It's in trust. It's life. It depends. So part of my, education process with a client is to let them know, even if you have a will, if you don't have a will, get a will. Great. But even if you have a will, that's not typically enough. So an estate plan, estate planning is a concept, but procedurally, it's really a lot of different documents, and it's a you or I going through and saying, tell me what accounts you have, bank account, brokerage account, life insurance. How are they titled? Whom do you want them to pass to? And then we have to go individually and say, well, this can go through the trust. This will go through probate. This will whatever. For folks that die and they don't have a will, there's extra steps to get somebody appointed, but to explain why there is no will.
Yeah. And that's what I was going to bring up. Maybe the big difference or the misconception is not so much around probate, but people thinking that it's not a big deal whether they have a will or not, because in both of those, it's still probated. But why is it different if you have a will versus not having one?
Yeah, if you have a will, certainly, think of it, it's your right to vote. If you have a will and it said, I've got 3 children, I leave everything to my wife and then my 3 children equally. Great. If I don't have a will, my wife only gets half. My kids still get something. That may not be what I intended. And so the law is going to going to fill in those blanks. And sometimes those blanks are not what the client otherwise would have wanted. So it's your opportunity to vote. You've got 3 kids. I'm blessed to have 3 wonderful daughters, but let's say you've got a rotten apple. I've got one right now and they're disinheriting a child. Millions of dollars. If they don't have a will, that child is going to participate equally with the other children. By having a will and trust and other estate planning, they're basically exercising their right to vote, in this case, to vote that child out of the plan.
Yeah, so they can control it while they're still alive, what happens after they're gone.
Absolutely.
Okay. Now, that kind of leads into the contesting part, which you do, I think from your website, you do a fair amount of that. So I'm fascinated by this whole will and trust contest part of your practice. So on a high level,
spend a week with me. You want to go running?
I want to talk about the drama or the controversy when people get mad at each other. All right. So on a high level, what is like a will and trust contest? What is that?
It's not like there's a win. It's not like there's a winner. I guess there's
right. I know there isn't. Probably not. Right.
Yeah. So when you contest the will or trust, basically you're challenging. You're challenging the document. So if a document says, my example, I've got 3 children and you leave everything to 2 of them, that 3rd child at death may bring an action, typically in the probate court or the circuit court, challenging the document. The challenges are numerous. The challenges could be undue influence. Oh, my other bad brother, my other bad sister poisoned, mom or dad's mind against me. Mom or dad lacked testamentary capacity. They didn't know what they were signing. They were mistaken. There was fraud. There was duress. There's a whole laundry list of those things. And if the challenge is successful, then that document typically is set aside and or the parties will agree to some sort of settlement. Rarely, honestly, from hundreds of thousands to hundreds of millions, rarely do these things get tried. They typically will settle out. One of the other hats I wear is a certified circuit court mediator. So oftentimes I'm not actually the lawyer, but I play one on TV. I'm not the lawyer, but I'm kind of the facilitator in a negotiation or participate in a lot of mediations. And that may be the first time in 2 or 3 years, honestly, that the family members have not spoken through counsel or actually in a room together and have spent a significant amount of dollars and a significant amount of tears and heartache and getting to that point. And I say it's like herding cats. At that point, hopefully they're on the same page and ready to resolve it. Typically, these things do get resolved. The sweet spot in my practice, and I think generally, is probably 3 to 5 years. So, depending on your age reference, whether it's a Perry Mason or LA law or whatever legal, these things do not get resolved in 30 minutes with a commercial break or 60 minutes with a commercial break. So it's 3 to 5 years, knockdown, drag out. I've had situations where there've been more than a dozen lawyers involved. We're reasonably compensated here. And I'm not throwing my colleagues down south or up north under the bus. But a lot of you say my old guy, my pay grade, Miami, you're probably $1,000 an hour. New York, $2,000 an hour. I had a case recently down in Naples where I showed up representing the personal representative. It was me and him. The other side of the room, there were 14 other people. The judge walked in. It's usually, 2 of us, and it's a 15-minute hearing. The judge walked in. He looked down. There's like a room full of people. He says, "Is everybody here for the Smith estate?" He looked down and he goes, "Is anyone here not a lawyer?" And he's kind of like, like eye contact, like, "Is anyone here not a lawyer?" He said, "Ladies and gentlemen, it's going to be an expensive afternoon for your clients. Will you figure people coming down from New York, coming up from Miami, Atlanta, Boston, Sarasota, Naples, coming down the night before?" So that was probably a $75,000 day in what was a 5-year lawsuit. So this is not for the faint of heart. I try to talk people out of litigation. It's a lot cheaper without me, but it is a process. It is a process.
Yeah, and emotions are involved. And when there's large amounts of money, then people get tied up in all of that. Okay, now you kind of glossed over some of this. I'm going to ask you about a couple terms, what they mean. So real quick again, undue influence. How is that defined?
Yeah, so undue influence is basically, so mechanically, I'll give you if I'm pleading, I'll default to lawyer mode. If I'm pleading undue influence in a lawsuit, undue influence, basically I have to establish that the alleged undue influencer, the bad brother, the bad sister, the caretaker, whomever, has a confidential relationship with the decedent. That's usually easy to prove. Their son, daughter, the caretaker. That they substantially benefited in the documents. Gee, I just met the Hooters waitress on the cruise last week and I left them $3 million. There's substantial benefit. There was a relationship. And the third element, and it's conjunctive, so you have to have all three, is that there was what they call active procurement. And that's a fancy term. And there's a case, it's called the Carpenter case, a seminal case in Florida. I'm a Gators fan. I say Seminole, not Seminole, but the seminal case in Florida is called Carpenter. And it basically, the Florida Supreme Court back in 1971 listed 7 factors that if those factors, and it's not like 5 out of the 7, just if a bunch of those factors are present, they will create what they call a presumption of undue influence, a presumption of active procurement. So it's things like if this bad person found the lawyer, took the person to the lawyer, knew the context of the lawyer, and none of the other family members did, kept the copy of the will, all that kind of stuff. If those presumptions are present, then basically, usually the person contesting a will, right? If I'm suing somebody, the burden's going to be on me, what's called the burden of proof. The burden is on me, on my client, to establish those elements. The unique thing about in the area of undue influence in Florida, unlike pretty much every other thing I litigate, it has what they call a shifting burden. And so the first burden is there a valid will? If they can't establish the will's valid, we're done. Yeah. If they establish, no, it's properly signed, then the burden's on me to raise these Carpenter presumptions. And if I do, it used to then be on me to prove the case. Post-Carpenter, there was a change in public policy and a change in the statute. Because of public policy, now the alleged undue influencer has to prove that they weren't an undue influencer.
Okay.
And so it's it's a difficult litigation. There's a lot of discovery, a lot of subpoenas, a lot of depositions, a lot of getting medical records, things like that. I think the telling fact for your viewers, I use it when I do my presentations, my webinars. I actually stole it from somebody else. I forgot who. It's estimated that there is 34 billion with a B dollars a year that is misappropriated nationally through undue influence. And the culprits are typically family members and caretakers. So whether it's $1,000 from, grandma's Social Security check or $10 million from $34 billion a year. So it is rampant.
Yeah. And I'm sure in a lot of cases, the truth is probably stranger than the fiction. All right. So let's jump to another term. I don't know if I'm saying this right. Tortious interference. Did I pronounce that right?
Close enough. Tortious interference.
Okay. So what is that?
So tortious comes from the root is tort. So like a tort. Okay. So a tortious interference is essentially when somebody has gone out of their way to, screw with, jeopardize somebody else's inheritance. Okay. And so whether they've poisoned the mind of the parent, the grandparent, whatever. Now, the interesting thing, Florida does recognize tortious interference. It's a claim that can be brought. The wrinkle in tortious interference when I file a lawsuit, sometimes these are 60-page lawsuits, you will never see tortious interference pled in any of my lawsuits. The reason for that is not because I forgot. Like all of these have their own elements. So like undue influence has all that Carpenter. In tortious interference in Florida, it is what they call an alternative remedy. What does that mean? That means I might have to go through that 3, 4, 5-year lawsuit, and I've pled undue influence, fraud, duress, lack of testamentary capacity, mistake, yada, 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 alpha and omega, and I get my walking papers struck out across the board. If the client still has a little gas in the tank, and if I still have a little gas in the tank, we can then come back as an alternative grounds for relief, tortious interference. If that is pled in an initial complaint, so I've got count 1, undue influence, count 2, fraud, count 3, but mistake, count 4, tortious interference, the first thing opposing counsel is going to do, or if I'm opposing counsel, is going to move to strike that, move to have that removed, because it's what they call, I'll give you another legal term, it's not right. It's not right for adjudication because we can't have that conversation until we've had all those other conversations.
Okay. All right. That clears that up. Thank you. So
clear as mud, right? Clear as mud.
No, I totally get it. Without sharing any confidential details, can you give me like a recent example where you were able to dramatically help a client get the type of result that they were looking for?
I'm involved in one now. I may have to check back if I get the result I want, but it's an unfortunate situation. It's actually a colleague of mine that I've known 20 some years. Unfortunately, he's suffering from dementia. He was otherwise a very sharp guy, very successful guy, has some mental issues, deficits, has been kind of taken advantage of by a former coworker who got them to sign all sorts of, and this is a person like you and I who's in the industry, right? You know lawyers, I know financial planners, we know bankers. I'm not like a drywall hanger or a school teacher. Right. I mean, this is what we do. We know these people. This is a guy who's been doing this for probably 35 years. This individual, this undue influencer, downloaded some forms off the internet, had herself named as his guardian, as his agent of power of attorney, as his healthcare surrogate, as his pre-need guardian. Took them to a UPS store. No problem with the UPS store. I use them all the time, but just not to sign legal documents. Great for shipping boxes and now UPS commercial, but not really where I want to have my documents signed, especially if they're challenged. And a guardianship was established. And all this was, I was unaware of it. He reached out to me. The family reached out to me. We're in the process of trying to unwind that. But the problem is it's in court. She's the legally appointed guardian. And I've got 30 subpoenas out there. I'm scheduling depositions. I'm doing it for free. It's just not right. I will bring my A game, but it's just unfortunate. And if he were actually having to pay for this, I mean, you're talking significant dollars for a client who's got diminished capacity, and it's just a downward slope. And you got the wife, you've got young kids. It's just very, very unfortunate. And unfortunately, got an old pissed off lawyer who's willing to bring his A game. So we'll see.
Well, that's to be determined.
Stay tuned.
Stay tuned to be determined. Okay, so let's switch gears a little bit. We can still stay on your A game, but what's
left of it, right?
Yeah, that's right. What are you liking best about your practice right now?
Pretty much what I've always liked. I mean, I enjoy meeting people. I enjoy helping people. Really, I'm kind of like me and my colleagues, yourself included, for a lot of what we do, we're kind of like the last lap around the track for people. We are trying to put a plan in place that's going to carry out their final wishes when they're either no longer able to because they're deceased, or like this individual because of diminished capacity. We're kind of that next step, and I've there used to be an old commercial. I forgot who it had. It was something like the tagline was, "It's the next best thing to being there." Yeah. I want to be at my children's wedding. I want to see my grandchildren graduate. I want to do all those things. It's up to the man upstairs whether those things happen or not. But if I can't, if God forbid I have a heart attack, car accident, time to meet my maker, whatever, it's nice to know that there is a plan in place so that my yet unborn grandchild can go to college, so that my daughters can get married, so that they can get their first house, so that whatever, I want to be there and I hope I'm there. But for our clients, again, the next best thing to being there is having a plan in place. And for a lot of families where there might be a disabled child, my middle daughter is diabetic. So we're talking about, here's you need to call the CPA, and here's where our will is. And here, hey, this kid would have needed a shot within an hour and her blood sugar tested within an hour of us dying. I mean, that's boots on the ground for a caretaker. It's not like call the lawyer in a month, make sure those taxes are filed. She needs a doctor and a prescription refill within probably a day. We try to put that planning in place, put those go-tos, put the contact lists. I think it's very helpful along those lines for your clients to have a contact list. I like to say, who's the lawyer, who's the accountant or CPA, who's the financial advisor, the insurance planner, just have that list out there somewhere where everybody has it. They may not necessarily, some of my clients are ambivalent. Not everybody wants to share documents from day one, but at least if you have that go-to list and they can say, oh yeah, I remember Taso, he's that old lawyer, he retired. Or I remember Chris, he's down in Miami now. But if there's 8 of our names on there, somebody's going to go, oh yeah, no, Chris has just changed office. He's still doing the same thing. Here's his new address. Oh no, Taso decided to join a firm again. Or it's just helpful, because imagine it's like parachuting into somebody's life, right? You parachute into somebody's life. Now, if it's a spouse, it's different. If it's a close one, but I have situations, especially in Sarasota, older folks die, maybe the spouse is predeceased, and I'm dealing with a niece or nephew up in Connecticut or New York or Miami. Did they have life insurance? Who was their broker? Were their taxes filed? And you're literally, it's forensic accounting. You're going through their checkbook. Did they have a life insurance policy? I don't know. If they paid a monthly premium, I'm seeing a check. What if they paid an annual premium? What if it was a 10-year-old policy and was paid up? How do you find that stuff out? It can be done. It's a lot of forensics. It's just a lot easier if you leave a trail of breadcrumbs.
Yeah, that's really well said. And we encourage the clients to be as best organized as you can. All right, so let's switch gears a little bit. What would you say at this point is your biggest life accomplishment so far?
I've been married almost 40 years, and I have 3 daughters who are all doing very well.
Yeah, I thought you might say that. You've mentioned them a few times. That's great.
I'm an old softie. A bad day at work is not. It's all about the family.
Right. I agree.
Keeps it all in perspective.
Yeah. And outside of your practice, is there something that you're really passionate about personally?
Well, because of my daughter's diabetes, I serve on a number of boards. I've served, probably 20 years on the Juvenile Diabetes Foundation, both locally, and now I'm on the chapters are reorganized, but I've been on the board for probably 20 years of that. I serve on the board for All Children's Hospital as well. I do a lot of work with the Florida Bar. I've been on the executive council of the Florida Bar tax section for 20 plus years. So professionally, again, from that standpoint, mentoring young lawyers, young law students, personally, again, trying to be active with the children's activities, hospital, medical.
That's great. And the mentoring thing is priceless, especially for people that are coming up.
Whatever you do, even if it's not a great job and if you made mistakes, if you can just, it's like that pay it forward kind of thing. If you can just kind of tell people, like you say, if I was talking to a younger version of me, there's definitely things I would have done differently. There's things I would do the same. There's goal expectations, goal management. We're in a situation now, with this whole remote thing. It's different. And so I think you have to be fluid. You have to be flexible. We were chatting before we went on air. Since the pandemic, pre-pandemic, I would be anywhere from Jacksonville to Naples, Jacksonville to Miami, Naples to Palm Beach within a week. I've gone from Jacksonville for an afternoon hearing to Miami for a hearing in the morning, same day. I literally have been in court twice in the last 2 years. And once was just recently, in addition to my law practice, in addition to being a mediator, I do a lot of subject matter expert work, both state and federal courts. And I was 3 days as an expert witness up in Orange County. But other than that, most of it's remote. The technology existed. I probably didn't have 5, whatever the predecessor was, go-to meetings or Microsoft Teams in the last 10 years. Now I have anywhere 3 to 5 Zoom conferences and or court appearances a day. So, even old guy, young guy, you just gotta stay flexible, stay engaged, stay current.
Yeah, you got to shift with the
embrace it. Change is going to come. You're going to either get hit by that truck or jump on it and go.
Yeah, what's the quote that I tell my kids? If you don't like change, you'll like irrelevance even less. Okay, so we're getting close to the end. I'm curious what you see as your biggest opportunity in the future of your practice. What are you seeing? Biggest opportunity?
Really, the law has been fairly stable in my area, so that's a good thing. I think what we're going to see, at least with some of the larger clients, is going to be recycling back to some of the planning we were doing, 10, 20 years ago. And why do I say that? So when I started practicing, so on the tax side of my practice, which interrelates with the estate planning side, when I started practicing, I still had hair, so that's a few years ago. Basically, the amount of individuals' assets that could pass tax-free was $600,000.
Yep.
That stair-stepped up, 6, 750, million, $1.5 million. Fast forward to today, fast forward to January of this year, it's a hair over $12 million. So husband and wife, 12 and 12, or husband, wife and wife, whatever, a married couple recognized under the law for tax purposes. I do a lot of seminars. I've always done a lot of seminars. And you don't want to be like, trying to be the smartest guy in the room, like, oh, I've got this guy worth $20 million. A lot of these clients are, maybe $500,000, $200,000, whatever you have is whatever you have. It needs to be passed. You need the documents, no issue. But the reality is in my wheelhouse, unless somebody has an estate, north of $25 million, they're not really going to have an estate tax problem. Now, they still need a will. I mean, no one wants to leave $10,000 to a 5-year-old, right? You still need a will. You still need trust. You need advanced directives, healthcare surrogates, powers of attorney, living wills. You need all that stuff. But on the tax side of my practice, unless somebody's north of that $24, $25 million mark, really, it's not going to be an issue. That said, that amount is set to expire in 2025, and that's baked in. And I'm absolutely apolitical. So a lot of people are like, well, that was Bush, that was Biden, that was Trump. This thing was baked in. They kicked the can down the road. Whether you like the current administration, whether you don't, that thing was going to expire in the next administration. And it was done by a former administration. I always say that the IRS, it's like the Postal Service, right? They're almost like a fourth branch of the government. They're just out there, this behemoth. And so what is likely to happen sooner, though, rather than later, is this $12 million is going to get reduced. We don't know exactly to the amount, but if it resets and it sets, say, back to the $5 or $6 million level, or $3 million, or God forbid, the $1 million that it was many, many years ago, a lot of the stuff that we were doing for these quote unquote, and I don't say it in a pejorative sense, smaller estate. Most estates are smaller than $25 million, but smaller taxable estates, we're going to be doing a lot. There used to be a lot more. My disclaimer, I'm not licensed to sell insurance. I deal with a lot of it. And it's a wonderful tool in planning. Tax efficiency is you can probably speak to that. But we use insurance a lot less than we historically did, because it was historically used as a hedge to pay the estate tax. If someone owes $10 million in estate tax and the IRS wants their check in 9 months, and you've got a family business, you sell the building and keep the parking lot. It's usually homogenous, right? No, very few people can write a check for $10 million. Insurance would plug that gap. But really, right now, unless you've got that north of $25 million estate, taxes aren't so much of an issue. I think when this clock resets, the big opportunity for me, for you, for people in our professions is going to be to dust off some of that planning that we were doing for, and again, I don't mean it, if you got $100,000, that's a lot of money, but for stuff we were doing for maybe $1 to $3 to $5 million states, we're going to be, and now we're just doing for $50 million states. I think there's going to be a resurgence of that. So, so kind of what's old is new,
Right. That's what they say about fashion. The bell bottoms eventually came back into play.
I've got my wide collar suits and then the narrow, and then they come back.
Yeah, right. Yeah, I like it. Okay. Now, on the flip side of that, what do you view as your biggest obstacle or challenge that is facing your practice or the business right now?
The one thing that the Florida bar is wrestling with, and so that has obviously a trickle-down effect, is the ability of non-attorneys to provide legal services and or non-attorneys to have an interest in law firms. And that's just kind of like, we're a highly regulated profession and like and should be, right? You don't want just somebody out there drafting documents. People say, I downloaded this form off the internet. I was like, hell, I'll give you my forms. You're not paying me for forms.
Yeah.
You're paying me. And, it was more impressive back in the day. I would say I'm an analog guy in a digital world. Now everything's online. But if someone says, oh, you have a form. And I'd go back and pull out 4-inch binders. Yeah, here's my forms. You want to take those home for the weekend? You're not paying me for the forms. You're paying me for which ones are appropriate, which ones are not appropriate, how they use, how they interrelate. It's not just all the stuff's on the internet. And the internet's probably been the worst thing for most, people self-diagnose and then they die a week later. Well, I thought I went on the internet and, the fish oil supplement didn't help me. But the funny thing is, and this was something that back when I was practicing in big firms 25 or more years ago, it's really a phenomenon in the United States. In Europe and some of the other countries, it's just a thing. I mean, so the largest employers of attorneys, for example, in the United Kingdom, are the accounting firms. So the ownership and interest in law firms and legal practices by non-lawyers, while new to the United States, new to Florida, and each individual state bar is dealing with it, it's not really a thing internationally. And then you've got a lot of law firms that outsource. It is what it is. I'm actually using an attorney for some property transfers in Greece right now. And this guy is a wonderful lawyer, speaks probably 7 different languages, emails 4 and 5 times a day, supremely knowledgeable, senior partner at a major firm. They do a lot of shipping international. They're based in Athens, charges $100 an hour. I mean, in the United States, a paralegal is probably charging $150 an hour. So I think the outsourcing, we're going to see more of that. It's just a more leveraged way of providing legal services. But like you were saying earlier, I think it's still, you need boots on the ground. You need someone to kind of be quarterbacking what's happening. And if it can be provided in a more timely, more cost-efficient manner, why not?
Yeah, I often say it's a difference between knowledge and wisdom. So there's a lot of information and potential knowledge on the internet. The wisdom part is lacking there. That's being able to put all the puzzle pieces together and figure out how it applies to you and whether you should do it or not based on your situation.
A client will come in and say, I need an S corporation. Why? Well, my brother-in-law just started a business. He needed it. And I'll generally say something to the effect of, I'm joining this party late. Tell me what you're trying to do, not your brother-in-law, what are you trying to do? What are you trying to accomplish? What type of business structure? The reality is you may end up with an S corporation or now limited liability company or whatever, but it's not a one size fits all. And in people, that's probably most of the time I spend is usually explaining stuff and educating. Like you said, the information is out there, but people may not necessarily understand it. And it's not because they're stupid. It's just a lot of information. And they just don't have the skill set to connect those dots. It's not their wheelhouse.
Or the brother-in-law was just a talker, and they were very persuasive.
Amen. Okay. Hopefully not an undue influence or just persuasive.
That's right. Or a tortious
interference.
Interferer. There we go.
Interferer. So
if people want to learn more about you or contact you, what's the best way for them to do that?
Yeah, give me a call, email. My email address, tmilonas@wealthlawgroup.com. You can Google my name. I'm on there. I think it's the last time I checked, I think they're the only 2 Tasos out there are me and a Greek clarinet player in Philadelphia. So there's not a lot of us.
All right,
but I'm the one that's the lawyer, and I used to.
Don't click on the don't click on the clarinet player. That's
no, you don't. You won't hire for that.
Okay. Listen, Taso, I want to thank you for taking the time to be here with me today. It's been a real pleasure to interview. Yeah, and I want to thank everybody for listening and watching, tuning into the Confident Retirement Podcast, brought to you by LPF Advisors, where we're raising the retirement confidence of everyday people to another level, one show at a time. Thank you, everyone, for tuning in and for watching. Take care and be well. We'll see you next time.
You've been listening to the Confident Retirement Podcast with Chris and Mark from LPF Advisors. For more information on them and retiring confidently, please visit lpfadvisors.com. If your ears are pleased and your mind is now at ease, do share the program with your friends and subscribe wherever podcasts are found.